Hi, I am Shane Reed. I'm an attorney at Weinberg Roger Rosenfeld. I'd like to talk to you about new worker protections for public sector temporary workers in the state of California. So, on October 10th, 2023, Governor Newsom signed Assembly Bill 1484, which took effect January 1st this year. And this new law amends the Myers-Milius-Brown Act, or MMBA, to include temporary workers in bargaining units alongside their permanent counterparts. So previously, the MMBA empowered local public employees to participate in collective bargaining, but temporary employees often lack these same bargaining rights as permanent staff, which really had a detrimental effect on their work conditions and benefits. And California public sector agencies have increasingly relied on temporary workers to fill a wide range of duties that are often the same or incredibly similar work duties to those of permanent employees, when in reality these workers are not actually temporary but may occupy these positions for many years or indefinitely with no promise of permanent employment. So now, AB 1484 defines temporary employees broadly, encompassing roles from seasonal to per diem workers. And under this law, when a recognized union requests, temporary workers will automatically join the same bargaining unit as permanent employees. Let me repeat that. As soon as the union makes a request, temporary workers are automatically added into the same bargaining unit as permanent employees. AB 1484 also mandates that upon hire, temporary workers must receive clear information about their job description, wage rates, benefit eligibility, and the length of their employment. And this transparency also extends to representative labor organizations, which must be informed about the hiring of any temporary employees within 5 days. So, public sector employers now have a duty to inform unions within 5 days whenever it hires a temporary worker, and all the union has to do to represent those workers is make a formal request. So this is obviously a much more streamlined process to facilitate, the increasing union density in the public sector, and it's very telling that AB 1484 was met with enormous opposition from the employer community because it just calls out and directly addresses the issue of the overuse and abuse of temporary workers in the public sector. The law also specifies that issues like seniority credits upon gaining permanent employment and hiring preferences for temporary workers must be negotiable, and any violations of these provisions can be addressed through unfair practice charges with the California Public Employment Relations Board, or PERB. For more information on your rights under AB 1484 or to seek further guidance, please contact your local union or your usual labor council. And thanks for watching, folks.